Okay, so wrapping it up here today, I'm going to talk about employment discrimination, continuing our unit on employment law. Thursday, I'll do the same. You have two cases for this unit that we'll discuss on Thursday. Um, so be sure that you've read those cases before Thursday's class, and then that'll wrap it up. Next week, I thought that I was going to have a trial on Tuesday and miss class, but it got moved, so I'm open next week. What I'll probably do is just have class Tuesday and we'll review for the final. And then Thursday, I'll be available during office hours if anybody wants to come talk to me about anything. So this is the last unit we're doing. You have a quiz for this unit due Monday. Don't forget that your discussions are due this weekend, Friday. You need to have all those done by Friday if you can. And yeah, this Friday. And your interview stuff's due this Friday too. All right. Everybody good on that? We're wrapping it up. Remember, I said this last week, but I'll say it again because I don't want anybody sweating about it. Our exam is take home. It's due at your convenience. I will give you the questions. It is mostly reflective. You do need to reflect back to me actual things that we learned and talked about, but it's kind of up to you. It's not going to be multiple choice, true, false over the stuff that we've already been over. So again, we'll talk about that on Tuesday when we review. I'll give you some examples of a good answer, a bad answer to these type of self-reflection questions, and hopefully that'll give you an idea of what I'm expecting. But if you have questions, now's the time to ask this week and next week because we're at it. We're down to it. Okay, so we are in the middle of employment law, and I left off last week where we got to employment discrimination. So today I want to focus on employment discrimination. That can take two forms. One is intentional discrimination, okay? I didn't hire you because you're Baptist. I didn't hire you because you're from Australia. I didn't hire you because you're old. Okay, intentional. There's also unintentional discrimination. That comes in what we call disparate impact. Think for a second about, I was going to say remember, I mean, this is still a thing, but think about the argument against standardized testing being discriminatory against certain populations, socioeconomic or race, things like that. In other words, that the theory is that those tests have built-in bias against certain classes. Okay, so that it's not that the SAT authors set out to create a test that discriminates. It's just that when you look at the data on the back end, you can see that one class or one race or one group of people does worse than others. The theory then is that there's something inherently discriminatory about the test itself, not intentionally, but resulting. That kind of carries over to employment discrimination as well. Let's say that I run a warehouse and I employ 1,000 people in my business. And the surrounding area that my business is in, the population of the racial breakdown in my area is 50% minority, 50% white. Okay, I have 1,000 employees. I give them a test, an aptitude test on warehouse knowledge or something like that. All right, there's nothing inherently on its face discriminatory about my test. You could read through it. You would say there's nothing on here that it doesn't say what race are you, right? That would be discriminatory. But as a result of me using that test in my hiring practices, let's say that I hire 100% white in my warehouse. but the labor pool in my area is 50-50. There's something going on there in my test that's skewing the results. That's the idea of disparate impact. Okay, that's the idea of disparate impact. So we can have intentional discrimination, that's disparate treatment. We're treating one person intentionally different than another based on race, religion, national origin, age, gender, disability, all the things. Disparate impact is when we're not intentionally choosing one over the other, but the result of our processes and procedures makes it look like there's something in the mechanics of it that's skewing the results one way. Disparate impact, this unintentional discrimination, is usually proved statistically, right? And it's usually proved after the fact, right? So when you go through, let's go back to my warehouse example. Let's say that I had a minority applicant who didn't get hired because they scored lower on the test than the person that I did hire. They suspect that they've been discriminated against. If their case against me is one-on-one, it's going to be very hard for them to prove intentional discrimination because there's nothing in my test or in my procedure that says we're not hiring minorities. Their best case is to aggregate the results of my test and hiring practices over a long period of time to show statistically that there's something going on. Does that make sense? Right? If we took a snapshot of one hiring day, let's say I had 10 openings. Last week, I hired 10 non-minorities for those openings. They try to take me to court. I lay out the test results. Everybody took the same test. I hired these 10 people who made the highest scores on my aptitude test. They just so happened to be non-minority. That's a hard case for the plaintiffs, for the employees to make in front of a judge or jury. Because I'm telling the judge or jury, I gave them a test. These are the ones that scored the highest on. What's discriminatory about that? But if they could show results of a hiring practice over years or over a longer period of time, and their numbers are statistically significant, then that's a much stronger case for them in court. Okay? It's very easy for me as an employer to go to court and say, these are the 10 people who scored the highest. But if I'm looking at 10 years of hiring data, then it's harder for me to explain why the only people that ever pass my test or get the jobs from my test are the non-minorities. Okay, so the longer a period of time, the more data points you have, the better case you could have for disparate impact. That's unintentional discrimination. Now, if it's one-on-one and the employer did something that is intentionally discriminatory, again, that was, I didn't hire you because you're Methodist. I didn't hire you because you're from Australia. I didn't hire you because you're old. Okay, we don't need statistics and large sample numbers for that. That's one-on-one. We got the evidence there. Since the Trump administration part 2, so since last year, beginning of last year, they have begun, he has instructed the Justice Department, which is the lawyers for our country, to not prosecute discrimination claims and cases as hard as they have in the past. He has, or the administration altogether has, that kind of goes hand in hand with them dismantling a lot of DEI stuff. But discrimination is a very, very low on the priority list for this particular Department of Justice. They're not very interested in suing employers for discrimination. They have talked about getting rid of the disparate impact, the unintentional discrimination altogether. It's not completely done, but that's if they were to carry, if they get the courts to go along with that unintentional discrimination, in other words, where you prove the discrimination based on statistics and that kind of thing, that would go away. It's not gone away yet, but that's the way this Department of Justice is heading on that. They're also encouraging lawsuits to be brought for discrimination against white people, against the majority. So if you see in the news, the reason I'm bringing this up is I want you to recognize when you see in the news anything about employment discrimination, that it's a very fluid area right now, and it is in the news. So I want y'all to understand this is an area of law that's in flux a little bit. So when you see that, pay attention to it. And I spent a little bit more time this morning explaining disparate impact and disparate treatment so that you would have a little bit of a background when you run into current events or news having to do with those sort of things. All right, the main piece of anti-discrimination legislation, the big law that we have, is Title VII of the Civil Rights Act of 1965. Most people just call it Title VII. This is a federal law, so it's nationwide, and this is the law that makes it illegal to discriminate in employment on the basis of race, gender, national origin, religion, sex, all those things. I'm not going to test you or expect you to know which federal law applies to which class, because there are a bunch of different ones, and they all do the same thing. So Title VII applies to race, national origin, gender, religion, those kind of things. We have a separate law that says you can't discriminate based on age. We have a separate law that says you can't discriminate based on disability. I don't need you to know which law goes with which one. I'm more interested in you knowing what a protected class is. All right, a protected class is created by these laws. This is a group of citizens that share some common characteristic that cannot be used in making employment decisions. Okay? It is important to know that these laws cover people not just who are actually members of those protected classes, but they protect people who are perceived as members of those protected classes. So if I'm not Muslim, but I wear Muslim clothing, and CSU fires me because they think I'm Muslim, it doesn't matter that I'm actually not a practicing Muslim. What matters is that they perceived me to be. Same thing can go with race. Same thing with national origin. You know, I might be born in America. My parents might be born in a different country, but I'm born here. I'm a citizen. But if I'm discriminated against based on employment because of my appearance and my employer thinks that I'm from another country, that's discrimination, even though I'm not. All right, so appearances, perception also matter. It used to be that you could think of a protected class for just about everybody except for white men under 40. What we're seeing now with some of the different theory in the Department of Justice is that they are prosecuting discrimination cases under the idea that everybody's a member of a protected class. Everybody is. If you didn't get a job, or if you got fired or demoted or not hired, or you had some adverse employment action, and it was based on discrimination of whatever class you're in, whether you're majority or minority, that's discrimination. So that is another idea that's taking hold and growing a little bit more. Just out of curiosity, do y'all know what the age cutoff for age discrimination is? Do you know how old you have to be to take advantage of the Age Discrimination and Employment Act? Say that louder. Nope, not 16. Not 62. Lower. Lower. 40. 40. So who said the 6? Whoever said 16? If you're 16, they can, or if you're 21, 22, it's actually legal for you to be not hired because you're too young. Now, under the current Department of Justice theory, they would encourage that 22-year-old to go to court and say, well, if they hired somebody else who's older than you and they didn't hire you because you're young, that's discrimination. Why do we need a cutoff on that? But 40 is the cutoff on that. All right, so in this employment discrimination lawsuits, let me back up. We talked early in the semester about administrative agencies, right? These are the arms of the executive branch of the government that are charged with carrying out the laws. OSHA, the IRS, the Environmental Protection Agency. There is an executive agency on a federal level called the Equal Employment Opportunity Commission, EEOC. Y'all have probably heard that before. The EEOC's job is to review every single complaint of employment discrimination and decide if they want to take it on themselves, sue the employer for the employee, or if they're going to let the employee take the case on their own. So because of this setup, if you have an employment discrimination claim, before you can go to court, you have to file a complaint with the EEOC. This is not the usual way that our court system works, right? Usually if you want to litigate, you want to sue somebody, you march down to the courthouse and you file the paperwork. Not so in employment discrimination. You first have to go to the EEOC. You tell them, you fill out a written complaint form, you submit it, it's reviewed. They either decide that they will prosecute it for you, which they do a very, very, very few cases do they actually prosecute themselves. And then after they review your claim, they give you a right to sue letter. Then you take that to your lawyer and then you go sue. Okay? Whether the EEOC thinks that you have a good claim or not, you still get to sue. Whatever they did at their review stage, that's not admissible in court. So maybe I file a claim with the EEOC saying that I did not get a promotion this year because I am Catholic. And the EEOC looks into my complaint. They get CSU to respond. The employer always gets notice of this, and the employer can respond. And EEOC looks at it and says, we don't really see anything here. But feel free to sue if you want to. CSU can't then go to court and say, well, the EEOC didn't find anything wrong with it. So it's almost, I want to say it's a wasted step. It's a screening out process, kind of. I think it's something that's probably in need of revision, but that's for another topic for another day. But that is the way it works currently. You got an employment discrimination claim. You have to go to EEOC first. They review it. After they've reviewed it, then they allow you to go to court if you still want to do that. All right. If we do go to court, if an employee does go to court, employee is the plaintiff, employer is the defendant. The employee, plaintiff, has to make out a basic case for employment discrimination. They have to show this, that they were a member of a protected class. These days, that's pretty much everybody. That they applied and they were qualified for the job in question, either as a new hire or a promotion, or that they held a job, that they were rejected or fired, that they suffered what the law calls an adverse employment decision. Demotion, termination, not hire, those type things. Discipline. Discipline could be an adverse employment decision that could be based on discrimination. So they got to prove I'm a member of a protected class. I'm 54 years old. I'm over 40. I was qualified for this job that I wanted to get promoted to in the business school, and they rejected me. I think it's because I'm old. All right? So I'm going to put that in my lawsuit. I've got to show that they hired somebody else who is not in my protected class. And if I can do that, I've made out my basic case for employment discrimination. All right? What happens if I can make out all the first three elements, say I'm a member of a protected class, I'm old, I tried out for this job, I didn't get it, and I take them to court, but the person that they hired was 60. I can't make out my basic case then, right? Because how could I be discriminated against on the basis of age when they hired another person that's in my protected class? All right, so once the employee meets those four basic things, this is a different thing about employment discrimination law than other areas of civil law. Most of the time in a civil case, the plaintiff makes their claims, and then it's up to the defendant to defend themselves, put up a defense, disprove the plaintiff's claim. All right, in employment discrimination, the burden kind of falls on both. All right, regular litigation, the burden is on the plaintiff to prove the case. In employment discrimination, once the plaintiff makes out this basic case that we just laid out, then the burden shifts temporarily to the employer. And the court says, okay, employer, Thibault made out his basic case. He's old, he applied for the job, you didn't hire him, and you hired somebody younger. All right, employer, this is your turn to tell us what was the real reason that you didn't hire him. Okay, so the burden shifts for a second from the plaintiff to the defendant. The court looks at the defendant, this is at the beginning of a case, and says, what is your reason? They've got to give a legitimate, non-discriminatory reason. If they say our reason was because he was too old, I win, right? Case over. But they may say, Professor Thibault's performance reviews were terrible. We interviewed 5 candidates and they all got scored, and he was the lowest scoring candidate. Maybe he's been here only 3 years and the person that we hired has been here 15 years. They might have a legitimate reason, and that's their time to tell the court what it is. Once the employer says what their reason is, then the burden goes back to the plaintiff employee to try to prove why that reason is false. Okay? So that's how all cases get set up. I show up in court, I show my basic facts. The court says, okay, you've made out your basic case. Employer, what is the reason that you took this adverse employment decision against this employee? They say it, then they look back at me and say, okay, Mr. Plaintiff, time for you to prove that their reason was false, that it was really discrimination. If I can convince the judge or the jury of that, I win. If the employer can convince the judge or the jury that their reason was legitimate, they win. That's how an employment discrimination case shakes out. In some of these discrimination protected classes, like disability or religion, employers are required to make accommodations for employees based on their need for them, based on their membership in that protected class. For example, I'm Jewish. I take off traditional Jewish holidays that the mainstream workforce does not observe. I go to my employer and say, I need to have this day, and this. I need these 3 days off. They're religious holidays for me. That's a reasonable accommodation that the employer is required to do. If they don't, they have discriminated against me based on my religion, and I can have a discrimination lawsuit against them. So it's not just, did they hire me? Did they fire me? Did they not promote me? It could also be, did I get the reasonable accommodations that I've asked for? Okay. Now, I can't go and ask my employer, I can't make up a religion and say that it only allows me to work between the hours of 10 a.m. and noon. Okay? That's not a reasonable accommodation for me to work 2 hours a day, 5 days a week. The employer is not required to grant that. The law just says reasonable. Who decides what's reasonable if we have a disagreement about it? Say it, Elrod. Who decides? If me and the employer have a disagreement about whether or not an accommodation is reasonable, and we go to court, the judge or the jury. That's right. The law just says it has to be reasonable. It doesn't give a list of things that are reasonable and aren't reasonable. Hopefully by now y'all have seen that not most, but a lot of the definitions in the law just give us a standard, like reasonableness. And they don't define it further than that. It's going to be up to the judge and the jury to decide based on the facts and circumstances and evidence in that particular case. So back to accommodation for a second. Employers are required to grant reasonable accommodations unless it would cause the employer undue hardship. Okay, again, that's a little bit of a vague standard. The judge or the jury would decide undue hardship. But in my example about me being only able to work from 10 to 12, let's say that the job is for a school crossing guard. Okay, that would be an undue hardship on the employer to give me an accommodation that doesn't match up with the hours that the job actually works. That makes no sense. Discrimination based on gender. That includes, I want y'all to understand, that includes pregnancy discrimination. Okay? Obviously, you can't discriminate because somebody is a female or because somebody is male. We're going to get to the in-betweens in a minute. But you could also discriminate against a female based on, let's say that I'm hiring, I'm doing interviews, and I have two candidates. One is a single female in her 50s, and one is a newlywed female who's 30 years old. Okay? If I don't hire the younger one because I'm thinking in my head, well, she's prime age to start having babies, which means she's going to be out a lot, which means she wouldn't be here as much, which means she wouldn't be as dependable. I think I'm going to hire the other lady because she's past childbearing age. She's not likely to have these interruptions. That's discrimination based on sex, on gender. One of the cases that you have assigned to read for this week is a recent case. I say recent, it's within the last 10 years. And it is a Supreme Court case. It started in Georgia. It was a DFACS worker out of Clayton County who believed that he had been fired because he was homosexual. And up until this case, courts had interpreted Title VII to not include sexual orientation or identity. Is that what I'm trying to think of? Is that the right word? Anyway, I may have messed that up. In other words, you could discriminate based on sexual orientation or identity. This gentleman from Georgia lost his job. He believed it was because he was homosexual. He sued the state government. It went all the way to the United States Supreme Court, and the U.S. Supreme Court said, yeah, I know that in the past courts have found that Title VII doesn't cover sexual orientation, but we're going to read it to say it does. Remember way back to the beginning of the semester when the court overturned Brown versus Board of Education and the idea of separate but equal. The court does, over time, change the law. And this is one area where they did. So after the Clayton County case, going forward, all courts would have to respect the Supreme Court's decision that Title VII does cover sexual orientation. Gender identity has not been tested in the courts yet. But based on the rationale and the explanation given by the Supreme Court in the Bostock case, I would expect that gender identity would also end up being covered, but it's not been tested yet. So that's one of the cases that you have to read for Thursday. The other case for Thursday is about a gentleman who believed that he needed several accommodations for his job based on his disability, and they were denied, and he was fired, and he and the employer disagreed over whether or not they were required to provide him those accommodations. There's two interesting cases for you for Thursday that we will talk through. That's how that works. All right, let's go to, let me talk for a second about constructive discharge. So sometimes an employee does not get fired, but they quit their job based on the idea that the working environment was so hostile that they were basically forced to quit. Okay, I didn't get fired, but it was so bad that I had no choice. I know I quit, but I was really forced to. It really wasn't voluntary. The legal term for that is constructive discharge. I didn't get fired, but I really did get fired. Even though I quit, I was really fired. That comes from this idea of hostile work environment. Hostile work environment can exist. It probably is most famous for hostile work environment through sexual harassment. But hostile work environment could be religious. It could be race-based. It could be national origin-based. Could be religious-based. Could be sexual orientation-based. All of these things. If the work environment is so bad that a person just can't stay there, say there are comments made, or there are jokes told, or the language used is just so bad that it's too hostile for the person to work there, then that would be a form of employment discrimination. All right, so that bleeds us into sexual harassment. One way of sexual harassment is this hostile work environment. Another form of sexual harassment is called quid pro quo, something for something. If you do this with me, I will get you the promotion. If you do this for me, I will give you a raise. If we do this together, I will hire you. That's quid pro quo sexual harassment. It doesn't have to actually happen. It's the offer, the insinuation, the demand. All right, once the offer or the suggestion or whatever happens, that's quid pro quo sexual harassment. You don't have to actually go through with it in order to then sue for it. When we talk about sexual harassment and hostile work environment, not just in sexual harassment context, but in all of them, there's kind of a sliding scale, right? So I want you to think about sliding scale in terms of severity. There is something that CSU could say to me one time that would be so offensive that I couldn't work here anymore? I'm not thinking of anything particular in my head. I don't have an idea in my head, but there would be something. You could probably each think of something that someone could say to you based on your age, race, national origin, all those things. There could also be something said to me that's pretty benign, that's inappropriate, but not horrible, okay? Or that might be interpreted different ways, that somebody might get the benefit of the doubt for. But if that same comment gets made every morning for a year or 6 months or 2 years, that might constitute a hostile work environment. So that's what I mean by sliding scale of severity. It's not just what was said, what was done, what was written. It's how many times it was said, how pervasive was it, how offensive in and of itself is it. And that's going to be different to all of us, right? If I'm walking down the hallway and Dean Kidder whistles at me, I might think it was funny the first day, right? If she does it every day for 2 years, it's not funny anymore. That becomes a hostile work environment to me. Maybe. So, point being, it's not always just one thing or one event. It can be cumulative. And you don't ever know what might be offensive or hostile to somebody else. You have to be very careful with that. All right, so sexual harassment, quid pro quo, something for something, and hostile work environment. Oh, retaliation. Retaliation is another form of discrimination. Okay, and that happens when an employee makes a complaint about any kind of discrimination. Sexual harassment, race, gender, religion, disability, anything like that. And the employer retaliates against them. That could be through comments, it could be through conduct, it could be through performance reviews, it could be through not hiring somebody, it could be certainly firing somebody, right? We all, I think probably everybody in here has worked at a job somewhere. We think real hard before we make a complaint about a coworker or a superior, right? Because we calculate in our head what the consequences of that could be. Is this going to be worse for me if I complain? Are they going to give me more of a hard time? If I complain about my supervisor whistling at me, I'm probably never going to get a promotion. I'm not saying these are legitimate, correct feelings. I'm just saying these are human feelings that we all have, right? So retaliation is a very real thing. I think almost all employees go through that calculus in their head. If I make this complaint, what's that going to look like for me? All right, so retaliation based on any complaint, any of these reasons, is employment discrimination. So hopefully what you can see from today's discussion is employment discrimination can take a bunch of different forms. It's not just I fired him because he was Catholic. That certainly is discriminatory, but it's not always cut and dried as that. We could have employers retaliating. We could have hostile work environments. We might have a hostile work environment that the employer didn't have anything to do with creating. But if they allow it to knowingly exist and go on, then they can be liable for it. Let's say I work in a warehouse and I'm the only old person in there. I'm the only person over 40 in the warehouse. All the other workers in the warehouse make fun of me every day for being old. They think it's cute. It's not really mean. They just, that's just the culture that is in our warehouse. Everybody gives everybody shit for stuff. I get it because I'm old. All right. I get tired of that. I tell my employer, hey, they're making fun of me in the warehouse because I'm old. I'm tired of getting called grandpa. Right? If my employer doesn't do anything about it, they can't go to court and say, well, it's not our fault. That was his coworkers doing that. If they know about it, they have to do something about it, which is important for employees who do need to make a complaint. That can be used against you sometimes if you didn't make your employer aware of the problem. Now, let's say that you don't necessarily have to make them aware of it. If they should have known a different way, they could still be liable. Let's say that my supervisor comes in the warehouse every day and he hears all this. I've never complained about it, but he's heard it. He's heard these guys making fun of me for 2 years. And I finally sue for hostile work environment. His defense cannot be, well, I didn't know, he never complained about it. I didn't know it bothered. So as managers of people, you need to be very aware of the surroundings, the environment, the talk, the culture that you're allowing to happen, even if somebody hasn't complained to you about it. Now, I will say that in today's society, I think we have very much a victim mentality. And anytime something goes wrong, we have a tendency to look for reasons to blame somebody else. And that's not to say that there aren't legitimate reasons to blame somebody else. I mean, there are. Discrimination is very real and discrimination happens. The reason I'm making this point to you is that as a manager of people, you can't go around trying to figure out what's in somebody else's head or what somebody else meant. You got to document everything. You got to go by policy. You got to follow the law. You got to treat everybody the same. You just don't have a crystal ball to know what's going on in people's minds. You don't know what might offend somebody. You can't worry about that. You got to enforce your policy. You got to enforce the law. You got to apply things fairly and consistently, and that's the best you can do. I had a client for about 15 years that was the health department in LaGrange, and they had the state of Georgia for health departments are divided up into regions, and it was not just LaGrange, but it was some surrounding counties. And they would call me whenever they had employment issues. Tom, we just interviewed 5 people for this job. This is the person that scored the highest. This is the person we want to hire. Here was the applicant pool. Here was their characteristics. What do you think? Do you see anything potentially discriminatory about our decision? Tom, we just interviewed 5 people. We want to hire the person who scored 3rd highest in their interview, but here's the reasons why we want to hire them instead of the people who scored higher. All right, tell me about them. Who are the candidates? What was their experience? Why is it that you're choosing them over the others? As long as you can articulate to me a legitimate reason that we can back up with evidence, I'm fine with it. But my job is to kind of hear that out and see if I saw any holes in that. I might say, you're going to have a really hard time justifying hiring that person who scored 3rd highest. I just think you're asking for trouble there based on the characteristics of the other people in the group. Tom, we want to fire this person. We've had it. Well, have you taken them through progressive discipline? Have you given them a warning? Have you coached them? Have you given them a reprimand? No. Well, what have you done with other employees who did that? Because if you took other employees who had the same offense and you gave them written reprimands or warnings, then that looks a lot like discrimination to this employee if you don't give them a written warning or a reprimand. We want to be consistent with our decision making, and we want to be able to justify our decision making in non-discriminatory ways, preferably quantifiable, evidence-based justifications. All right. Does anybody have any question on that? I'm saving, we're not going to get into disability until Thursday because I think that goes better with discussing the disability case. And then also, my 11 o'clock class is behind y'all a little bit. You're ahead of them. So I want to keep everybody together. So we're going to quit early today. So I'll see y'all on Thursday. Please read your cases. If you came in late, let me know.